Welcome to everyone that is joining. We are going to give it about a minute or so for everyone to log in. All right, it looks like our numbers are slowing down, so we will get started. Good afternoon, everyone, and welcome to our final webinar in the Spring Canadian Trademarks series. My name is Tierney DeLuzio, and I am an associate in the Trademarks Practice Group at Smart and Biggar. My colleague, Mark Bernacki, and I will be your speakers for today's presentation on tips and tricks on Canadian and U.S. trademark prosecution and enforcement. I would like to start with a couple of housekeeping matters. Our formal presentation will last for slightly over 30 minutes and will be followed by an open and interactive Q&A session where we will address any questions you may have. You are welcome to submit questions at any time during the presentation by typing them into the Q&A panel, which can be accessed by clicking on the Q&A button at the bottom of your screen. Please do not type your questions into the chat panel. We will try to address as many questions as we can during our live session. Today's webinar will be recorded, and following the presentation, we will circulate an email with a replay link together with a PDF copy of the slides from the presentation. At the end of the webinar, a link will pop up to complete a survey. We would appreciate if you could take a few minutes to complete the survey and provide us with your feedback on today's webinar, as well as what topics you're interested in learning about. Before we begin today's webinar, and in the spirit of reconciliation, we would like to respectfully recognize and acknowledge that the land we are meeting on and that all Canadians live on, work, and enjoy is the traditional territory of many nations. In Toronto, where Mark and I both work, the land is the traditional territory of the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and it is covered by Treaty 13. We understand that land acknowledgements play only a tiny role in reconciliation. So if you're interested in learning more, we recommend that you visit whos.land online. Now we will begin with a brief introduction to Smart and Biggar. We are Canada's leading intellectual property law firm with expertise in all areas of IP, including trademark, patent, and copyright. We now have over 125 lawyers, agents, and technical consultants, and we have been serving clients for over 130 years. A brief outline of today's webinar. Mark and I will highlight tips and tricks for U.S. brand owners looking to protect their trademarks in Canada. First, I will go through 5 things to look out for when prosecuting trademarks in Canada, emphasizing differences from the United States. Then, Mark will cover 4 topics related to litigating and enforcing those trademarks. Today, I will specifically be focusing on 5 types of objections raised during the examination of an application by the Canadian Trademarks Office. And to start out, the first tip relates to the way goods and services are described in a trademark application. The Canadian Trademarks Office has some of the strictest requirements in the world when it comes to the degree of specificity required in a statement of goods and services. In fact, by far the most common type of objection raised by Canadian examiners is that the description is too broad. According to the Trademarks Office, nearly 75% of trademark applications receive at least one examiner's report. And of those reports, nearly 65% raise an objection on the basis that one or more of the goods or services contained in an application are not described in a sufficiently specific manner. It can be challenging and quite time-consuming to address these types of objections. It is often not enough to simply amend the description to be consistent with what has been used and accepted in other jurisdictions, like the United States. So what can you do? When you're looking to file a new application in Canada, applicants are faced with a balancing act between the desire to obtain the broadest scope of protection possible with the desire to avoid a goods and services objection. One valuable resource is the Goods and Services Manual. This is a free document managed by the Canadian Trademarks Office, and it's available online. It contains over 130,000 terms that have been pre-approved by the office. If a term is selected from the manual, it will be accepted by the office without further specification. However, it is worth noting that simply because a term is not included in the manual does not mean that it won't be accepted by the Trademarks Office during examination. The terms in the manual can also be used to gauge the degree of specificity required. There are also limitations to the manual. It is far from exhausted. Many applicants will not be able to rely exclusively on the terms that have been pre-approved. In particular, the manual features few pre-approved terms for emerging and technological industries, for things like artificial intelligence or Internet of Things devices. That being said, the manual is actually a living document. The Trademarks Office will accept recommendations for terms to add to the manual. And this can be particularly helpful for applicants that plan to use the same description for large numbers of applications. There is another benefit to consulting the manual, which is the availability of accelerated examination. As I'm sure many of you know, the Canadian Trademarks Office is currently significantly backlogged, with examination taking place more than 55 months after filing. Examination is automatically fast-tracked without the need for an explicit request when all of the goods and services listed in an application are pre-approved terms from the Goods and Services Manual. According to current statistics, in such cases, the application is examined in roughly 17 months instead of 55 months from filing. Please note that this option is only available for national applications, and it is not available for Canadian designations of international registrations. So if it is possible for you to use terms that are pre-approved in the manual, there is a clear benefit to doing so. Perhaps the second most common type of objection raised by the Canadian Trademarks Office during examination is a confusion objection. In assessing the likelihood of confusion, the Canadian Trademarks Act instructs that examiners must consider all the surrounding circumstances, in addition to the 5 factors explicitly enumerated in subsection 6.5. One such surrounding circumstance is a letter from the owner of the cited mark consenting to the use and registration of the applied for trademark. In the United States, such consent is accorded great weight and is often effective in overcoming a confusion objection. In contrast, consent agreements are generally given very little weight in Canada and rarely convince an examiner to withdraw an objection. If the Canadian Trademarks Office concludes that there is a risk for confusion among consumers, it will maintain the objection to fill its role of protection of the public, despite the fact that there is an agreement during the parties. A recent Federal Court of Appeal decision provides a cautionary tale about coexistence agreements and trademark consent documents. Tweaked Inc. applied to register the trademark Tribal Chocolate in association with, among other things, hair dyes. the Trademarks Office raised an objection on the basis of an existing registration for tribal, also for hair dyes. Tweaked filed a coexistence agreement from the owner of the tribal registration. The agreement put in place certain safeguards meant to guard against actual confusion. For example, Tweaked would limit the sale of its goods to mass market retailers and drugstores and would not sell to beauty salons or spas. The parties agreed that compliance with these restrictions was sufficient to avoid any likelihood of confusion. The examiner nevertheless maintained the objection and refused the tribal chocolate application. In its view, the coexistence agreement provided only contractual protection between the parties. Tweaked appealed this to the federal court and then the Federal Court of Appeal, neither of which disagreed with the examiner's objection. So what can you do? Firstly, don't provide a bare bones consent. The document must do more than simply state that the parties do not consider their respective marks to be confusing. A consent agreement may still be helpful if it provides supplemental information to assist the examiner in concluding that no likelihood of confusion exists. The Canadian Trademarks Examination Manual is worth looking at because it includes a list of factors that the examiners might find helpful. For example, an explanation as to how the parties' goods, services, channels of trade, or businesses differ. So it is important to keep this in mind when negotiating coexistence with other parties. For the third tip, I will cover distinctiveness. As most of you are probably aware, the distinctiveness of a trademark is now substantively examined by the Canadian Trademarks Office. Since June 17, 2019, the Trademarks Office has had the power to object to the registration of an application on the basis that the applied for trademark lacks distinctiveness. Nearly 5 years later, we have learned that Canadian examiners are willing to wield this new power with enthusiasm, and we still don't have any jurisprudence setting out what it means for a trademark to be sufficiently distinctive to be registrable. So what can you do if you face a distinctiveness objection? The first option is to file a written response arguing that the mark possesses at least some inherent distinctiveness. You could remind the examiner of the distinction between a mark that has no inherent distinctiveness and a mark that has low inherent distinctiveness. When you consider the fact that distinctiveness is a spectrum, the threshold for some distinctiveness is actually quite low. The second option is to file evidence demonstrating that a trademark has acquired distinctiveness or secondary meaning, as it is often called in the United States. To establish acquired distinctiveness, it is necessary to file an affidavit evidencing the use and advertising of the applied for trademark in Canada prior to the filing date of the application. There is no defined threshold as to what evidence will be sufficient to establish distinctiveness, as this is something that is entirely within the particular examiner's discretion. Nevertheless, a minimum number of a few years and significant sales in Canada is typically required. Ultimately, it means that consumers have become so familiar with the trademark that they immediately recognize it as pointing to the applicant as the source of the associated goods or services. Establishing acquired distinctiveness is not an option for marks that have not been used in Canada as of the filing date. It is thus important to consider the distinctiveness of a trademark when developing a filing strategy. Applicants must weigh the pros and cons of either obtaining an early filing date or delaying the filing to wait for substantial use of the mark to occur first. Considering the distinctiveness of a proposed trademark early also allows for alternative strategies, like filing for a composite mark that contains a distinctive design element or a house mark. Finally, as a reminder, unlike the United States, Canada only has a single trademark register, the equivalent of the U.S. Principal Register. There is no Canadian equivalent to the U.S. Supplemental Register, which provides limited protection to marks that are unregisterable, but that are in use and may, over time, become an indicator of source. Our fourth tip today relates to a type of descriptiveness objection. In Canada, a trademark is not registrable if it is clearly descriptive or deceptively misdescriptive of the place of origin of the associated goods or services. In the past few years, we have seen an increase in this type of objection, including where the trademark is composed of an extremely obscure geographic location. We have seen examiners go to great lengths to find geographic significance. For example, small regions in Europe, like a village in Italy with a population of only 35. So what can you do? If the goods and services do not actually originate from the location, one option is to file a response arguing that the applied for trademark is not deceptively misdescriptive. For example, in the case of an obscure location, you could argue that the average Canadian consumer is unlikely to have ever heard of the place, let alone mistakenly believe that it is the origin of the goods and services. However, building on our previous tip, the office has recently started taking the position that marks consisting of geographic locations may nevertheless be considered not inherently distinctive, since no one trader should be able to claim a monopoly over a geographic location, regardless of whether that place is well known. So, while it might be possible to overcome a descriptiveness objection, the applied for trademark could nevertheless be refused on the basis of distinctiveness. The Canadian Trademarks Office has also been issuing examiner's reports in which the applicant is requested to provide confirmation that the goods or services originate from a particular location. So this might happen where a mark includes as one component a geographic name, something like Canada, for example. If the goods or services do originate from Canada, the examiner will be satisfied and there will be no objection based on the geographic significance of the term. However, if the goods or services do not originate from Canada, the examiner will consider the mark to be not registrable on the basis that it is deceptively misdescriptive of the place of origin. It is important to note that simply disclaiming the geographic name will not be sufficient to overcome the objection. Unlike the United States, Canada disposed of disclaimer requirements in 2007. We also highlight the benefit of proactive clearance searches prior to filing, and the importance of paying attention to whether any element or aspect of the proposed mark has any geographic significance. The final tip I will cover today relates to objections based on prohibited marks, which are far less common than the previous types of objections discussed. Prohibited marks are a unique feature of Canadian trademark law. Many trademark owners, even in Canada, are unaware of prohibited marks. Although they bear some resemblance to trademarks, they differ in several respects. In general, they can only be owned by universities, whether Canadian, U.S., or otherwise, or Canadian public authorities, like a government department. Prohibited marks are a significant form of intellectual property protection which never expire, are not subject to non-use cancellation, and do not undergo substantive examination. Protection may be granted even if the mark is, for example, clearly descriptive or a surname. A prohibited mark prevents others from using or registering an identical mark or any other mark that would be mistaken for the prohibited mark. This is different from the test for confusion in relation to trademarks, as the parties' goods, services, and business are irrelevant and completely ignored. So what can you do if you face a prohibited mark objection? The threshold for the mistaken for test is quite high, and in most cases, the applied for trademark must be nearly identical to the prohibited mark to be refused. So if the marks are not all that similar, it may be worth attempting to overcome the objection by filing a written response, arguing that the applied for trademark would not be mistaken for the prohibited mark. However, often the most straightforward option is to obtain the consent of the owner. The owners of prohibited marks are typically prepared to grant their consent, sometimes subject to certain conditions, like the payment of a small fee. Unlike confusion objections in relation to traditional trademarks, an objection based on a prohibited mark can readily be overcome through the provision of consent. The third and fourth options shown on the slide are available only for marks owned by Canadian public authorities, and these are sometimes called official marks. You can submit evidence to the examiner to demonstrate that the public authority no longer exists, or a party can challenge the validity of an official mark by bringing a proceeding in the Federal Court of Canada. The Trademarks Act has recently been amended to codify these last two options, and the Trademarks Office has published a draft practice notice outlining how it proposes to deal with these options. It will review a request, which should be accompanied by evidence, and if it is satisfied, it will send a notice to the holder of the official mark. If that notice goes unanswered during the prescribed period of time, or if the evidence provided is insufficient to meet the relevant test, the status of the official mark will be amended to read inactivated. While not yet in force, these legislative changes will hopefully create a simple and efficient mechanism to allow the Trademarks Office to declare that an official mark is no longer valid and enforceable. And now we will head to Mark to discuss some litigation and enforcement tips and tricks.
Thank you, Tierney. So as you say, we're going to shift our focus now from prosecution to enforcement. As with prosecution, there are many important differences between Canada and the U.S. when it comes to enforcing trademarks. I'm going to discuss 4 of those differences and how they impact trademark enforcement in Canada. In particular, I'm going to discuss differences between our respective courts, our legal proceedings, discovery, and remedies. So, turning first to differences between our respective courts. Both Canada and the U.S. have a federal court and provincial or state courts. In both Canada and the U.S., the vast majority of intellectual property disputes, including trademark matters, are heard by the federal court. However, unlike the U.S., where the federal court is divided into 11 different circuits comprising 94 different district courts, Canada has a single unitary federal court, and that's significant. First, in Canada, judgments and orders of the federal court are enforceable across the country. So injunctions issued by the Federal Court of Canada are generally countrywide. In contrast, judgments and orders issued by the U.S. district or circuit courts are only enforceable within the circuit that issued them. Second, in Canada, there is, for all intents and purposes, a single body of jurisprudence within the federal court. Contrast, in the U.S., there may be different and divergent lines of jurisprudence between the 11 different circuits. Third, as a result, at least in part, unlike the U.S., there is little to no forum shopping in Canada. The federal court in Vancouver is the same federal court in Toronto and Ottawa and Montreal. It has the same body of jurisprudence, and no advantage can be gained by commencing a federal court proceeding in one part of Canada over another. Another important difference is that, unlike the U.S., there are no juries in the Federal Court of Canada. All disputes are adjudicated by judges. Intellectual property disputes, like trademark infringement cases, can be complex. Having judges adjudicate such disputes reduces unpredictability. Furthermore, the Federal Court of Canada is very familiar with trademark issues and disputes. It has considerable IP expertise. The Federal Court of Canada only has around 30 judges. Many of those judges were leading intellectual property litigators before joining the federal court. They understand trademark issues, which further reduces unpredictability at trial. Moreover, all federal court judges in Canada are trained as mediators. Canadian litigants in trademark disputes have the option, if they both agree, to request that a federal court judge with trademark expertise act as a court-appointed mediator. And this can help resolve a dispute before it even gets to trial. So in my view, these features make Canada's federal court a relatively predictable and efficient jurisdiction in which to litigate trademark disputes. So next, I would like to turn to differences between our respective legal proceedings regarding actions and applications. So in both Canada and the U.S., trademark enforcement proceedings can be commenced by way of action. And at a high level, there are lots of similarities between actions in Canada and the U.S. Actions are the traditional way to commence enforcement proceedings in both jurisdictions. They involve the exchange of pleadings, setting out material facts, claims, any defenses. They involve pretrial discovery, both documentary and oral discovery. They involve trials, live witnesses and testimony. And they often take several years to get to trial. However, unlike the U.S., trademark enforcement proceedings in Canada can also be commenced by way of application. Applications are a much more straightforward procedure based entirely on a paper record. In applications, the parties exchange simplified pleadings and affidavit evidence, followed optionally by cross-examinations. There's no discovery. There's no live witnesses at trial. Instead, the parties submit written submissions and make oral argument based on the affidavit evidence and any cross-examination transcripts. Advantageously, applications can get to a hearing in less than a year and oftentimes cost far less than half of what a typical action would cost. Now, neither procedure is inherently better or worse than the other. They're simply different tools with their own advantages and disadvantages. For instance, if a litigant needs discovery or needs to call a witness to prove certain facts or aspects of its claim, then a traditional action is likely the best procedure. However, where a litigant already has all the evidence needed to establish its claims, which is often the case in trademark infringement proceedings, then an application may be an attractive procedural option in Canada that will likely result in a significant savings of time and money. So next, I would like to turn to differences in discovery between Canada and the U.S. So first, it's worth noting that there are many similarities in discovery between Canada and the U.S. For instance, we both have pretrial, documentary, and oral discovery in actions. And in that respect, discovery procedures in Canada and the U.S. have more in common with each other than many other jurisdictions like the U.K. or continental Europe, which either have more restricted discovery or in some cases, effectively no discovery at all. Having said that, there are several important differences in discovery between Canada and the U.S. as well. First, the scope of discovery is somewhat different between Canada and the U.S. In Canada, the scope of documentary and oral discovery is defined by relevance to unadmitted allegations of fact. In the U.S., my understanding is that the test is whether a document or question is related to the pleadings, which is arguably a little bit broader. Further, while both Canada and the U.S. are guided by the Sedona principles, which is a series of propositions regarding discovery, Canada appears to apply those principles more strictly, and particularly with respect to proportionality. which again further narrows the scope of discovery in Canada. For instance, I understand it's not unusual for U.S. trademark litigants to produce thousands of documents in the course of a legal proceeding, whereas in Canada, it's much more common for trademark litigants to produce on the order of hundreds of documents. A second important difference is that in Canada, litigants generally only get to examine a single representative of the other side. In contrast, in addition to corporate representatives, U.S. litigants are also entitled to examine anyone else who is likely to have documents or information related to the issues in dispute. As a result of these differences, discovery in the U.S. tends to be more onerous, takes more time, and is more expensive than discovery in Canada. Next, I'd like to turn to differences in remedies between Canada and the U.S. So in both Canada and the U.S., trademark owners can seek to recover from infringers their damages. So that is their lost profits on lost sales. However, my understanding is, unlike the U.S., in Canada, trademark owners also have the option of seeking an accounting of the infringer's profits. That is, profits the infringer made on its infringing sales. And since it is often difficult to establish actual damages from lost sales in trademark infringement cases, an accounting of profits can be an attractive remedy in Canada for trademark owners. Another important difference is that, unlike the U.S., Canada is a loser pay system. Under this system, Canadian courts will often order the unsuccessful party to pay a portion of the successful party's legal fees and all of their reasonable disbursements. This single difference dramatically alters the economics of litigation between Canada and the U.S. And as a result, the loser pay system reduces speculative litigation in Canada and provides a strong incentive for settlement. Indeed, in Canada, only a very small percentage of trademark disputes ever make it to a hearing on the merits. Another important difference relates to some other forms of damage. In both Canada and the U.S., courts can award punitive damages. However, unlike the U.S., the Federal Court of Canada also has an established practice of awarding significant nominal damages to successful trademark owners where actual damages have not been proven. And since it's often difficult to establish actual damages in trademark infringement cases, particularly in cases where you're moving for default judgment, this can be a particularly attractive remedy. Lastly, while courts in both Canada and the U.S. will grant injunctive relief to trademark owners, the Federal Court of Canada also has an established practice of granting Anton pillar orders to preserve evidence and ordering infringers to destroy or deliver up infringing goods and to transfer infringing domain names. Considering that the Federal Court of Canada's injunctions are countrywide, this makes injunctive relief for trademark owners particularly effective in Canada. So in the interest of time, I'm going to stop here, but I hope that this has highlighted some of the important differences in Canada and the U.S. in terms of enforcement and serves to show how Canada can be an attractive jurisdiction to bring trademark enforcement proceedings.
Thank you very much, Mark. We are now at our Q&A portion of today's presentation. So we will take a look at some of the questions that have come in. As a reminder, you can submit your questions through the Q&A panel by clicking the button at the bottom of the screen. So I've had a chance to look at some of the questions that are already coming in, and I will kick it off. Someone has asked whether prohibited marks can be identified and researched. And this is actually a great question. Prohibited marks are listed online in the Canadian trademarks database. So the same way you would search a regular trademark in the online database, you can also look for prohibited marks. And those marks will be notified appropriately as a prohibited mark. Something you can look out for is a notation that it is protected under Section 9 of the Canadian Trademarks Act, because that is the section that provides rights to prohibited mark owners. And I will also mention that if you do a pre-clearance search before filing for your trademark, that search should also identify any prohibited marks that are in the Canadian database. Mark, would you like me to pop a question over to you?
Sure. I see one enforcement related question. Let's see. Have there been any notable recent developments in Canadian trademark jurisprudence regarding enforcement of trademark rights? So, yeah, there's at least one that comes to mind. So, I think over the last several years, we've seen an increase in the number of successful claims for material misrepresentations under Section 7A of the Trademarks Act. And historically, this is a relatively unused claim under the Trademarks Act. So Section 7A of the Trademarks Act prohibits the making of false or misleading statements tending to discredit the business, goods, or services of a competitor. And as I said, largely it's been unused. However, a few years ago, in a case that I handled for U.S. Shores, we successfully brought a claim under Section 7A against a party that relied on an invalid trademark registration to base an Amazon takedown request to remove numerous product listings from UU's Amazon storefront, and that resulted in significant lost sales. And so in that case, the federal court found that the takedown request constituted a false and misleading statement, and it tended to discredit our client's business, and it awarded over $100,000 in damages. And since then, we've seen numerous other litigants in Canada asserting Section 7A in response to takedown requests. And more recently, the BC Superior Court granted damages under 7A in a case involving Kizio versus Skrunks. And that was a case where a trademark owner improperly took down a competitor's product listings on Amazon that was showing its registered mark in comparative advertising. And the court said that's not infringement, and you violated Section 7A. And in that case, the court awarded around $25,000 in damages. And so as a result, I think that trademark owners need to be a bit more mindful and careful in Canada when relying on their trademark rights to take down other people's web pages and product listings. It's not to say that you shouldn't do it. It's a powerful remedy, but I think it should be done mindfully and carefully, and make sure that you have a strong case before doing so.
Thanks, Mark. I see another question here about prosecution. Someone has asked for the mark Bagels Canada. What objections would be raised by the Canadian Trademarks Office, and how would you respond? So unfortunately, Mark and I are not here today to provide legal advice, so we can't advise you on that. But this is a great example of when you could consider conducting a clearance search. So asking your trademark counsel to run a clearance search for you, identifying any trademarks that might be considered confusing, also looking for those prohibited marks, and then they can also opine on the registrability of the mark in terms of descriptiveness or distinctiveness. Now, in terms of the tips that I did cover today, I will say that this mark, an examiner will almost certainly ask whether those goods do come from Canada. So you should be prepared to address that if they do come from Canada or if they don't. So I encourage you to reach out to your trademark counsel for that one.
And you'd probably face a non-distinctiveness objection as well if you had a mark like that.
Mark, would you like to take another one?
Yeah, so let's see. Why are so many trademark disputes litigated in the Federal Court of Canada rather than provincial courts? I get, why are so many IP disputes litigated in the federal court rather than provincial courts? There's a number of reasons. Firstly would be exclusive jurisdiction. So while provincial courts and the Federal Court of Canada have concurrent jurisdiction over many IP matters, including trademark matters, there are certain aspects that the Federal Court of Canada has exclusive jurisdiction over. And so, for instance, in trademark disputes, the Federal Court of Canada has exclusive jurisdiction for invalidating a trademark registration. Second reason is the Canada-wide effect. So provincial court orders are only effective in the province where they were issued, and federal court orders are effective across Canada. Also, depending where the activity is taking place, if, for instance, if it's only taking place in Ontario, then you wouldn't be able to sue in other provincial courts. And then a third reason is expertise, which I mentioned. Most federal court judges have trademark expertise. Unfortunately, most provincial court judges do not. And as a result, I'd say that the federal court is less unpredictable.
Thanks, Mark. So actually, another person has asked a question that I was just about to answer. So it looks like this is definitely of interest. So people are asking what happens when the goods and services manual changes and a term is no longer acceptable, which raises a great point. As I mentioned, it is a living document and you can request that terms be added, but CEPL also does remove terms on occasion. And my understanding is that if a term was approved in the manual at the time that you filed your application, then that term will still be considered acceptable. The examiner might miss that and they might still raise an objection based on that term, but you can go back and inform them that that term was considered acceptable, the date that you filed your application, and it should therefore be considered acceptable for you during examination. It looks like after this, we have one more question. Someone has asked whether it is possible to obtain accelerated examination after the application has already been filed. And the answer is yes. If you filed your application and now you would like to accelerate your examination, you can file a voluntary amendment to put all of your goods and services in terms that have been pre-approved from the manual. And this will basically allow you to jump the queue. So you'll be moved in from the pile of regular applications to applications based on terms taken from the manual. And you will be examined during that under that timeline. I got distracted there. We have another question. Someone has asked if the date of filing the application is the relevant date, why is the Canadian Trademarks Office objecting to old applications under the new law? So the relevant date that I mentioned in my response to the previous question is only in relation to the Goods and Services Manual. So the actual law that applies in terms of registrability of that trademark is the current law, the new law as of June 2019. So for example, distinctiveness. So just because your application was filed prior to the amendments that came into effect in June 2019, the new law still applies to those marks. So the relevant date being the filing date is only in terms of your goods and services description and whether or not it was in the manual. So unless there are any final questions that anyone wants to quickly type into our Q&A box, I think that is everything for today. Of course, if you have any further questions, you can feel free to reach out to Mark or myself or another member of our firm's trademark practice group. We appreciate everyone taking the time to join us today. Thank you, Mark, as well, for presenting with me. And we ask that all attendees complete the survey when the link pops up at the end of the webinar. Thank you again, everyone, for joining us today.
Thank you, Tierney. Thank you all.